So I asked the judge, can you swear us both in? And he said, no, we're not going to do that.
Well, you told him, you said you need it for appellate review. Say, is it not true that for any evidence or facts to be presented to the court, it has to come through a verifiable witness? And he'll have to say, yes, that's true. So say, before we start, just in case I need it for appellate review, I need to be sworn in, so that way my testimony can be heard by the appeals. Because if you don't, the only testimony that the appellate court is going to hear is something that was verified under oath of affirmation. So if it's not verified under oath of affirmation, you have nothing to appeal.
Really?
Really? Yeah, it's just that simple. I mean, all you have to do, it's a federal. If you actually like to play with federal rules, it's a federal rule of civil procedure, Rule 602. It's just personal knowledge. So, like I said, the only thing you have to say anytime you ever step before any kind of court is just that you have to say to the judge, is it not true that for any statement to be deemed admissible evidence, it has to be under oath of affirmation? And the judge has to say yes. He has no other choice. To be admissible evidence, you have to. And then you say to the judge, therefore, before we proceed, you just say, it's my wish to be sworn in through affirmation. Therefore, there could be admissible evidence pressed upon the record in the event that it needs to go for an appellate review. And that's the only thing. The appellate court only reviews things that were sworn in under oath of affirmation testimony. If there's no testimony for the appellate court to review, there's no case for them to hear. So you say, therefore, before we proceed, it's my wish to be sworn in through affirmation, and then I wish the other side to do for the same. And in the event you need appellate review, and Angela sees that on, she put that on her Irwin Schiff site. That case that I'm referring to is that Transy versus Pagliaro, 1964, where it says that no attorney could present any facts or evidence or onto the record unless he has any firsthand knowledge, and that's that Federal Rule of Evidence 602.